Friends, my name is K. Umesh Rao. Today's subject is Obitar Dicta, Ratio Decidendi, and Stare Disease. The subjects is part of precedents. We are discussing Obitar Dicta, Ratio Decidendi, and Stare Disease. Now we will take up Obitar Dicta. What is Obitar Dicta? It is a statement made by a judge in the course of his judgment, which may not be relevant to the issue before him. It is said by the court by way of casual statement. Statement is beyond the requirement of a particular case. The statement made by the court is irrelevant and unnecessary for the purpose of case in hand. This is called obiter dicta. For example, while disposing a public interest litigation filed against the government Bihar, Division Bench of High Court criticized the attitude of the Bihar government and said, people of the Bihar are living just like animals. There is no control on criminals. Criminals doing their atrocities as they like. Judges consider the pitiable circumstances of the Bihar state and its decisions. Judges expressed their views and criticized the state government. It may be observed that remarks expressed by the Bihar High Court is not ratio decidendi, but they are obiter dicta. It works as a warning to the people, to the police, to the state government. Obiter dicta has a force of persuasive precedent only. Judges are not bound to follow these rules. How obiter dicta helps the growth of law? Sometimes these statements help the cause of the reform of the law. Observation the judges are bound to carry weight with the government. For example, in the Bihar case, it will open up the eyes of the Bihar administration, Bihar police, and they may do some reform. The defects in the legal system can be pointed out in obiter dicta. So, obiter dicta has no such binding authority. It is a byproduct of the original judgment. They are the opinion of the judges and it does not give effect on the decision. Another term we are discussing is ratio decidendi. What is a ratio decidendi? It means when the highest court of India makes a rule in a case, or when the Supreme Court gives its judgment based upon that rule, that case becomes a valid precedent. The court gives reasons for the conclusions of the decisions. These rulings are called ratio decidendi. These rulings are precedent. In India, high courts of the states are bound by the decision of the Supreme Court. Likewise, all subordinate courts bound by the decision of the high courts in their respective states. What is the principle involved in this doctrine? Under above circumstances, when the case is decided between the parties, this matter becomes res judicata and parties cannot be the subject of further disputes. To study that, we should know what is the duty of the court. For example, when case comes, court has to first inquire into the details of the facts of the case. Later, court considers the question of law. Afterwards, court takes into account of transactions between the parties, oral and documentary evidences. Court will see what is the law in force, what is the precedents, and what is the prevailing customs All these are useful to the court in concluding the case. The judges should consider the case depending upon the actual facts revealed from the evidences. For this purpose, precedents certainly help him. Judges pursue the precedents and goes into the details of the rules. Each precedent has certain rules of its own. The court relies upon such rules. These rules are called ratio decidendi. Now we will take some case laws. Dinog versus Stevenson. The facts of the case: plaintiff went to the cold drink shop along with girlfriend. They purchased a ginger bottle of black in color. She consumed it and felt uneasy and started vomiting. It is observed that a decomposed body of snail was found in the bottle. Plaintiff sued the manufacturer for his negligence. Lower court dismissed the petition and dispute reached the House of Lords. House of Lords ordered the manufacturer to pay compensation for the plaintiff. Now, if the same type of case is filed before any court, the court considers the first ratio decidendi. Now, what is the ratio decidendi in this case? Defendant was a manufacturer of ginger beer. There was a decomposed body of snail in the black colored bottle. There was a liability upon the retailer to supply the merchandise goods or quality goods. He should take care. It is a fact that distributor doesn't know the presence of decomposed body of snail in the bottle. It was not his duty to test each and every bottle. He trusted the manufacturer. Retailer with bona fide intention sold the bottle to the consumer. Plaintiff's girlfriend did not notice the decomposed body of snail because bottle was black in color. Plaintiff friend's health spoiled. It is all the fact. The lawyer argued that there is no agreement between the plaintiff and the distributor or retailer to supply the quality goods. Court did not agree. Court said that it is the duty of the manufacturer to supply the quality goods. Now we will take another case, Bridges versus Hawksworth. Here, customer found a purse on the floor of the shop. Dispute arises whether such purse shall be given to the finder of purse or the shop owner, shopkeeper. Court found that finder is the keeper of the goods policy and gave it to the customers. Court treated shop as a public place. Like this, another case we have studied, South Staffordshire Water Company versus Sharma. Here, plaintiffs owned a pool. Defendant found two gold rings in the mud pool. Plaintiff claimed these rings. Defendant argued that basing on the Bridges case, court held that gold rings shall be given to the plaintiff because mud pool was owned and occupied by them. Whereas the Bridges case, shop was a public place and pond of the plaintiff was a private place. So ruling given is precedent if not related to the facts. So doctrine of ratio decidendi is subject below mentioned conditions. So what are the conditions? The ruling given in the precedent, if not related to the facts of the case, such ruling is not good. That means genuineness of the ratio decidendi. How to decide? The ruling given in a precedent, if not related to the fact of the case, then such ruling is not good and not binding. Second, if the ruling given is against the real intention of the legislature, it is not good ruling and it is not binding. If the ruling, when the court gives a new ruling, it is the duty to explain the reasons given in such a ruling. If the ruling is not rational and not reasonable, then such ruling shall not be taken into consideration. Obiter dicta cannot form ratio decidendi. When there are two or more judges and majority delivered their ruling, minority dissented, even then such ruling is valid ratio decidendi. Now we are discussing stare decisis. What is stare decisis? It means see the decisions, stand by the past decisions. Stare decisis is a principle of law. It has become settled by a series of decisions, generally binding on the court, and it should be followed in similar cases. What is the purpose of the stare decisis? It reduces the workload of the court. It is based on the public policy. It settles the law. It has to be followed, otherwise, every judge will decide the issue according to his own view. He may lay down rule according to his own perception. It is the case, it will cause inconvenience, inconsistency, uncertainty, and ambiguity. In order to apply the rule of stare decisis, there are two conditions. For the application of this doctrine, two conditions must be complied. For example, first there must be a settled hierarchy of courts in a country. For example, Supreme Court, under Supreme Court, High Court, under High Court, District Court. If there is hierarchy is there, then only this rule can be applicable. Second, there must be perfect codification of the decision of the Supreme Court and High Court. Now, what is the advantages of this term stare hierarchy? The doctrine helps the courts to dispose the cases early and efficiently. It reduces the expenses of litigation. It increases the convenience of the courts. Judges can easily come to the conclusion with the previous judgment on similar facts and circumstances. It helps to achieve certainty in the administration of justice. Thank you. This is the end.